Good morning, Cubaristas. So, it's Thursday, July 14th, Bastille Day, and what better way to celebrate the day than reviewing the slew of United States Supreme Court decisions rendered against the common good and the economic, civil, and social rights of the majority in favor of the economic ruling classes, for which only one reasonable conclusion is possible. The Supreme Court of the United States of America is the avowed enemy of democracy. First, we'll start off with a morning shot of espresso. Good stuff. Well, the U.S. Supreme Court, by its recent decisions, has made the idea of equality before the law a vile and contemptible joke. The rule of law the Supreme Court upholds is the golden rule of he who has the gold rules. It has corrupted the very fabric of their robes as well as the state and society they allegedly serve. The rule of their law has come to replace the consent of the governed, because reasonable people will not give their free and informed consent to seeing their economic rights, livelihoods, or means of redress taken from them. In reaffirming corporations as persons, giving them unlimited scope to bribe candidates as a form of free speech, and effectively nullifying the rights of workers to pursue class action lawsuits, the Supreme Court has cast off the last robe of judicial professionalism and revealed its naked bias as a hired servant of the wealthy, the powerful, and connected. It's time not just for its 9 lifetime dictators to be retired, but for the institution itself to be put in its place, the Smithsonian Institution. But how can we protect the fundamentals of constitutional law? Without a supreme body, how can you settle interpretations of right and duty and reach binding decisions? Obviously not with this scab of a Supreme Court sitting across the North American legal system. Interesting that our anti-statists, who are all for local rule and moral values, raised no protest when the Supreme Court placed the rights of game manufacturers and retailers above the rights of state legislatures and parents in protecting minors from violent video content. According to the Los Angeles Times, 20 leading American companies sent a brief to the Supreme Court supporting Walmart, stating that the plaintiff's theory in Dukes versus Walmart would have exposed companies to mass class actions even when they had adopted and enforced company-wide diversity policies. In other words, employment practices are the exclusive right of the feudal corporate patriarch to determine with no public input. The Walmart attorneys even had the gall to add that the plaintiffs were still free to pursue their individual claims and have them resolved for hundreds of thousands of dollars plus attorney fees. A cynical riposte that only underscores the necessity of class action suits in the first place, as a union of plaintiffs seeking redress in a capitalized legal system over a specific kind of grievance. But, being a capitalized legal system, need I add more? No, one sure remedy is needed to preserve what's left of democracy in the U.S., to ensure respect for both the spirit and the letter of law within the democratic Constitution, rather than look for reasons to deny it, like dishonest JPs paid a fee for every free chain gang worker they supply to local cotton planters. There must be a separation of money and state, just as there is separation of religion and state, and for the same reason. Those who don't care for the latter see nothing wrong with vouchers of public money supporting the theological indoctrination of society with their dogmas. Those who believe in using the state as a servant of mammon see nothing wrong with the rights of mammon as co-equal, even taking precedence over the rights of man. The legal system of the United States is on a par with its electoral system, no better than the corrupt scribes and Pharisees of Jesus' time who forgot that the law was made to serve all, not just a few, while turning the many into servants. The judicial priesthood of the USA needs, as Martin Luther, to nail their theses to the wall. I personally see capital not as a life-giving force, like this espresso, but a narcotic that damages the political body just as cocaine, heroin, and methamphetamines damage the physical body of the citizen. It must be vigorously controlled as any scheduled substance, insofar as it cannot be totally outlawed. We will not countenance for a minute officials of the DEA working hand in hand with the mafia and peddling narcotics in our communities, exposing our children to addiction and disease. But we think nothing of the likes of New York State Attorney Andrew Cuomo, looking the other way. No, advising prosecutors to go easy on Goldman Sachs when their fraud was exposed, subjecting American families to the destruction of their homes. Federal regulators and prosecutors who worked with the bank fraudsters, even though that meant children forced from their homes and threatened with hunger. Goldman Sachs is a den of thieves, and the U.S. judiciary is the hired servant of thieves, all the way to the Supreme Court. So, that's fine to state, but how to begin a redress in the legal system? Because the court system functions as an absolutist hierarchy inherited from medieval monarchies. Even the forms of address to courts reek of privilege invested autocracy, even if elected. Perhaps one way out of this is to nullify lifetime tenure for the Supreme Court. The objection that they should be above politics is fine, but in practice it's nonsense as it is, because they obviously aren't. If the other branches of national government are to be elected, then this one must be. Otherwise it becomes, what it is now, a bastion of private privilege and a canker corrupting what's left of the public integrity of the United States at all levels of government. Electing the Chief Justice, who would then appoint the 9 members of his so-called cabinet, or the 8 members of a so-called cabinet, serving only for the term of his election, would be a first step in the long-term disinvestment of capital in the legal process, weakening the links between the criminal class and the judicial class that predominate now. Perhaps eventually we could see the creation of a national ombudsman. Variants of this include a parliamentary commissioner or inspector general in other countries. The authority of such an official would begin and end with the case in dispute. As a public servant, he would be charged with representing the interests of the public good, and if there is any conflict between parties based on different but good faith interpretations of this public good, he must try to find a compromise that leaves the rights of both sides intact. As public officials, these ombudsmen would be elected in federal districts. Again, the issue of corruptibility and campaign contributions raises its ass, but with a mandate to interpret constitutional complaints for the common good of all parties, rather than make the contest a zero-sum game, the damage done by partisanship would be much less than it is now under the false flag of a biased body posing as impartial jurists currently in place in Washington. Anyway, that's just one man's idea looking for a way out of the legal shithole currently dug for us by the Supreme Court of the United States. I'm sure someone can raise good objections to it and maybe come up with even better solutions. But can my suggestions be any worse a concept than the corruption now so openly and proudly displayed, like sores of a diseased homeless addict? With the cozy little fireside chats with billionaires on policy, Clarence Thomas's personal checks and gifts received from reactionary activist Harlan Crow in connection with the Citizens United decision, as one example. And who knows how much unreported personal income flows into the accounts of the other jurists to keep the wheels of the legal system spinning one way. The slogan of the U.S. Supreme Court should say out loud, we're bottom, we're proud. Because before much longer we'll see the 8-hour day overturned, child labor restored as the rights of minors to earn income in an expanding free market workplace, maybe even the right of private places of business to decide whose business they want, with signs announcing what category of human is allowed on the premises and who is forbidden along with dogs. Maybe even we'll see the rights of the employer to the worker's labor returned back to its original status of the rights of the employer to own the worker as well as his labor. So, I was expecting that one. Hello, FBI? CIA? No? Oh, Thomas Jefferson again. What's that? Okay, you remember how the Supreme Court gave itself the right of judicial review precisely to block the democratic process and give your opponents a platform to attack you when they lost the election. Well, that's true. It looks like the American Revolution just overthrew one unelected autocrat, only to replace him with 9 more. I hear you, but the only trouble with hearing advice from you is, damn, did you have to keep those slaves for life? You know, because hearing you argue for the democratic process is like leaving it in the hands of Antonin Scalia, a rape bound to produce bastards.